is pleading to occurred on different dates and are based on different sexual conduct. So it's the state's position that those would not merge.
Thank you. Mr. Mastandrea?
Thank you very much, Your Honor. Rod Mastandrea on behalf of Kevin Kreider. Your Honor, that is an accurate recitation of the plea agreement that has been gone over with my client, and my client does intend to enter a guilty plea to those charges. Thank you.
Thank you. Mr. Kreider, how old are you?
Would you like us to stand?
No.
60.
How far did you go through school?
I graduated, but I don't have the knowledge to. I've got second grade reading.
All right. Are you able to read and write?
No.
Do you understand the English language?
Yeah.
All right. Prior to coming to court, have you taken any drugs or alcohol or any prescription
jail.
medication in the last 48 hours?
No, I've been in jail.
Have you ever been diagnosed with or treated for any mental illness?
No.
Did you get a copy of the indictment in this case?
Yeah.
All right, it's been represented to me you're going to plead guilty to count 6, rape, a felony of the first degree, count 7, rape, a felony of the first degree, count 13, sexual battery, a felony 3, and count 14, sexual battery, a felony 3, and then the remaining counts will be dismissed at the time of sentencing. Is that your understanding?
Yeah.
All right, before I accept your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you some questions. If you don't understand a question, stop me, or if you want to talk to Mr. Mastandrea some more, let me know and I'll give you more time. You understand that?
Yes.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. Do you understand that right?
Yeah.
Are you waiving that right?
Yeah.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Say that again.
If you go to a jury trial, all 12 members of the jury must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yeah.
Are you waiving that right?
Yes.
If you go to a trial, the prosecutor will call witnesses to testify against you. Do you understand that the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yeah.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If those witnesses refuse to come to court, then I'll issue an order called a subpoena to make them come here and testify. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the right to testify at a trial if you want to. Do you understand that right?
Yeah.
Are you waiving that right?
Yes.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Say that again.
If you went to a trial and you decided you didn't want to testify, nobody's allowed to comment on that. Nobody could say, look, he must have done it because he didn't testify. Nobody could say anything about it. Do you understand that?
Yeah.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
I understand what you're saying.
Well, if you went to a trial and you were found guilty at the trial, you would have a right to appeal that guilty verdict. Do you understand that right?
Yes.
And are you waiving that right?
Yeah.
All right. If you filed an appeal, then you would have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yeah.
Are you waiving that right?
Yes.
If you could not afford to hire a lawyer, one would be provided for you free of cost to you. Do you understand that?
Yeah.
If you were to file an appeal, you would be entitled to have a transcript of all the hearings in this case. Do you understand that right?
Yes.
Are you waiving that right?
No.
Pardon?
Let me see. Yes or no?
Yes, because it's a trial,
Yeah.
the appeal for the trial, not the appeal for the sentence.
So do you understand that right?
Yes,
And are you going to waive that right?
yeah,
All right. If you could not afford a copy of the transcripts, if it came to that, there would be no charge to you to get them. Do you understand that?
yeah,
All right. If you plead guilty here today, you will not have the right to appeal the guilty finding. Do you understand that?
yeah.
Do you have any questions about any of these rights that we've gone over? Do you still want to plead guilty to counts 6, 7, 13, and 14?
Yeah,
Do you understand by pleading guilty, you're fully admitting your guilt to the charges?
yeah,
Do you understand by pleading guilty to these felonies that you're voluntarily giving up your freedom for whatever period of time that I would sentence you to prison?
The stakes have never been higher in this courtroom. As the tension builds, the defendant's fate hangs in the balance. Stay tuned to see what happens next in this jaw-dropping case.
Mandatory prison sentence of at least 10 years up to your lifetime. Do you understand that?
yeah,
Count 7, which is rape, is also a felony 1 with a mandatory prison term of at least 10 years up to your lifetime. Do you understand that?
yeah,
Count 13, sexual battery, is a felony of the 3rd degree with a maximum prison sentence of 60 months. Do you understand that?
yeah.
You got to verbalize
Yes.
it. Count 14, sexual battery, is a felony of the 3rd degree with a maximum prison term of 60 months. Do you understand that?
Yeah,
On the counts 6 and 7, on each count, there's a maximum fine of up to $20,000 on each count. Do you understand that?
yeah,
And on counts 13 and 14, on each one, there's a maximum fine of $10,000 on each. Do you understand that?
yeah,
Now, I could give you a consecutive sentence. That means one sentence after another for the separate offenses. If I did that, you face a...
Your Honor, I did make a mistake in the plea paperwork. I put 30 years. That should be 30 years to life.
Right.
I explained it that way.
If I gave you a maximum consecutive prison sentence, then you would face a maximum prison term of at least 30 years up to your lifetime. Do you understand that?
yeah,
And the maximum fine would be $60,000. Do you understand that?
yeah.
Do you have any question about the penalties on these charges?
No.
And, Your Honor, you may have
Yeah.
already said it, but the prison is mandatory on count 6 and 7.
I did say that with regard to each count.
Thank you.
All right, you are pleading guilty to sexually oriented offenses, and by law you'll be classified as a Tier 3 offender. And as a result, you're required to register and verify information about yourself for in-person verification every 90 days. Do you understand that registration and reporting requirement?
Yeah,
I didn't hear your answer to that.
yes,
There are also requirements for reporting if you change your address during the term that you're required to report. Do you understand that?
yes,
The failure to register, failure to verify residence at specified times, or failure to provide notice and change of residence address or other required information will result in a separate criminal prosecution. Do you understand that?
yeah,
Do you understand that your felony conviction will prevent you from owning or possessing a firearm?
yeah,
Do you understand that after your release from prison, you will be placed on post-release control for 5 years under the parole authority?
yeah,
They will place conditions on you. If you violate their conditions, the parole authority could return you to prison for up to 9 months for each of your violations, up to 1/2 of my sentence. Do you understand that?
yeah,
If that violation is a new felony, then you could get an additional consecutive prison sentence for that violation. Do you understand that?
yeah,
If that were to occur, the maximum prison term for the post-release control violation would be the greater of 12 months or the time left under post-release control. Do you understand that?
yeah,
Do you understand that during the mandatory period of your prison sentence, you are not eligible for judicial release.
Under the mandatory term of your prison sentence, you cannot get out by the judges letting you out. You have to serve the mandatory time first. Do you understand that?
Yeah. Yeah.
You understand that?
Yeah.
Now, has anybody promised you that I would be lenient on you just because you're pleading guilty today?
No.
Has anybody promised you what I will sentence you to in this case?
No.
Do you understand at the time of sentencing, the prosecutor may make a recommendation, your lawyer may make a recommendation. You understand I don't have to follow either of those recommendations.
Yeah.
Have you had enough time to talk with Mr. Mastandrea before pleading guilty today? Have you had enough time to talk to Mr. Mastandrea about this guilty plea and pleading guilty today?
Yes.
Has he discussed everything about your case and answered all of your questions?
Yeah.
And are you satisfied with the advice he has given you?
Yes.
Have you been threatened or coerced in any way to plead guilty today?
No.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yeah.
Do you have any questions at this time?
No.
All right. Ms. Alessi, if this case went to trial, what would the evidence show?
The evidence would show that the victim in this case is Savannah Rux and the defendant is her biological father. And on or between December 7th of 2020 and March 2nd of 2025 in Lake County, Ohio, when the victim was between the ages of 10 and 14 years of age, the defendant engaged in sexual conduct with her, specifically fellatio, cunnilingus, anal, and vaginal penetration.
All right, Mr. Mastandrea, anything you want to add to those facts?
Thank you. No, Your Honor.
Mr. Kreider, did you hear what Ms. Alessi said? The facts would show if this case went to a trial.
Yeah.
And are those facts true?
Yeah.
What is your plea to count 6, rape of felony 1?
Guilty.
What is your plea to count 7, rape a felony 1?
Guilty.
What is your plea to count 13, sexual battery, a felony 3?
Guilty.
And what is your plea to count 14, sexual battery, a felony 3?
Guilty.
All right, Mr. Mastandrea?
Would you make?
Have, yeah, no, but have him initial in the margin and then have him, I didn't want to sign it like that anymore, just have him initial next to his signature, okay, and then you can sign it. In the margin and then next to his signature also, okay?
They just said there was an error in here. So you got initials right here for me. Just put your initials right here, and then put your initials right here. There.
Right where?
Right there. And then right next to your signature as well. Is that right, Jeff?
Yeah.
And then what?
Right over here too, next to it.
Yeah, you got, did you sign it, Rod?
Not yet. I'll sign it right now.
I've witnessed the defendant and his attorney sign their plea of guilty here in open court.
All right, Mr. Kreider, is this your signature on this written plea of guilty?
Yes.
And did you sign it voluntarily?
Yes.
Do you want me to accept your written plea of guilty?
Yes.
All right, I'll accept the written plea of guilty. Defendant was present with counsel, advised of all of his rights, made a knowing, intelligent, voluntary waiver. He understands the nature of the charge, the consequences of his guilty plea, and the maximum penalty. Find it to be knowing, intelligent, and voluntary, I will accept his plea of guilty and find him guilty of count 6, rape of felony 1, count 7, rape of felony 1, count 13, sexual battery, felony 3, and count 14,
With the defendant's plea now on the record, the legal consequences are just beginning. Stay with us as we continue to follow the outcome of this explosive courtroom drama.
The court convened to address an ongoing property dispute between Mr. Kalani and Mr. Smith. The matter focused on whether the defendant had properly complied with a prior court order requiring the removal of a portion of a fence to restore access to the rear of the property. At the start of the hearing, the judge confirmed that newly submitted photographs had been received and shared with both parties' counsel, including attorney Mr. Friedman. The discussion quickly turned to whether the defendant had fully complied with the court's earlier ruling. Counsel for Mr. Kalani argued that although the defendant technically complied with the court's order by removing several fence slats, the action did not satisfy the spirit or intent of the ruling. According to the plaintiff's position, the purpose of the order was to restore long-standing access to the backyard area, access that allegedly existed for approximately 90 years. While 10 wooden slats had been removed as directed, the plaintiff maintained that a chain-link gate and post still obstructed the area within the 20-foot section the court had ordered to be cleared. Because of this remaining post, they argued that vehicles or equipment would still have difficulty entering the backyard. The judge examined the photographs and questioned how the remaining post actually prevented access. The court emphasized that the primary issue in the case had always been unimpeded access to the rear of the property, not necessarily the total removal of all structures in the vicinity. From the judge's perspective, the remaining gate post did not appear to block entry into the backyard. The defense countered that the structure in question was not simply a fence obstruction, but part of Mr. Smith's driveway gate, which he had the right to maintain in order to secure his property. And defense counsel also explained that when the contractor removed the ordered section of fencing, it became clear that the gate post was separate from the wooden fence and was necessary to support the gate itself. According to the defense, the removal of additional fencing would not meaningfully improve access to the backyard and could potentially interfere with Mr. Smith's ability to secure his property. During the hearing, the judge referenced a personal visit to the site and described attempting to maneuver a large SUV in the backyard area. Based on that experience, the judge concluded that vehicles could still turn and access the space without significant difficulty, suggesting that the remaining post did not create a true obstruction. The plaintiff's attorney also attempted to raise concerns about alleged harassment and hostile behavior between the neighbors, including accusations that one party had made threats. However, the judge immediately declined to entertain those claims within this proceeding, emphasizing that such allegations were unrelated to the property dispute and would fall under criminal or separate legal matters. Returning to the central issue, the judge determined that the defendant had complied with the exact requirements of the court's previous order. Although the plaintiff argued that the remaining gatepost violated the intended spirit of the ruling, the court found no new evidence showing that access to the backyard was actually blocked. The judge acknowledged that there may have been some misunderstanding earlier about whether the gatepost was attached to the wooden fence. However, after reviewing the earlier photographs and the current situation, the court concluded that the defendant had removed the required fencing sections as ordered. As a result, the judge ruled that no further action would be taken at this time. If the plaintiff believed additional relief was necessary, such as relocating the gatepost, they would need to file a new motion for the court to review. Without such a motion properly before the court, the judge stated there was nothing further to decide. The hearing concluded with the court affirming that Mr. Smith had fully complied with the existing order. So while leaving open the possibility for future legal motions should the dispute continue.